On business protection from a private wealth and inheritance point of view. I'm Nicole Miller. I'm one of the legal directors here at Harrington Carmichael, and I head up the trust and tax team. And this is Kerry Parsons, who is one of our senior solicitors in the same team. So let's get started. A bit about Harrington Carmichael. We are a full service law firm offering legal advice to both individuals and businesses in the UK and overseas. We offer advice across all sectors. And in relation to the WISE sessions, just a bit of background. WISE is the Wednesday Insight for startups and entrepreneurs, and we offer these sessions each week alongside the workspace hub that we have within the office. And the idea behind the hub is to allow new businesses and individuals who are looking to kickstart their businesses to come and use the office space and benefit from some of our facilities for free. These sessions are intended to help provide those startup businesses with an overview of legal issues. In particular, today we're going to be covering business protection. So we'll be looking at wills generally, and in particular, wills with business interests, the importance of lasting powers of attorney, and in particular, business lasting powers of attorney. And then we'll have a brief overview of inheritance tax, and in particular, business relief for inheritance tax purposes. So Kerry is going to start.
So to begin with, I'm just going to talk about wills, what they do, what's the purpose of them, why we should have them. So as a lot of people already know, what a will does is it sets out what happens to your estate when you die. It says where your assets are going to pass. In the will itself, it will appoint executors and trustees, so you can choose who will administer your estate, so who will value it for probate purposes, who will collect in all of the assets, and who will deal with distributing those assets in accordance with your wishes as set out in your will. Trustees are also normally appointed alongside the executors in your will, and more often than not, they're generally the same people, but they don't have to be. Sometimes individuals want to include trusts in their will. So the trustees, their job with regards to a trust will be to manage the assets held within that trust for the named beneficiaries. The named beneficiaries would be appointed in the will itself as well. Wills are great because you can set out, as I say, where your assets pass. You can have as many different beneficiaries as you want to. And you can also set out in there how you want and what percentages you want those assets to pass. It isn't necessarily the case you would want your assets to pass equally to your beneficiaries. It might be that you want one beneficiary to have 50%, some to have 10%, and so forth. So it gives you that option to kind of split out your estate as you want, and to use trusts if you want to. It's also a really great opportunity for tax planning. There's lots of different exemptions out there, such as the spouse exemption, charity exemption. There's also various trusts, as I say, you can use, which are great for tax planning. So we can discuss all of that with you if you wanted to do a will, and we can make sure we get the best from those available exemptions. So what are the benefits of having a will? Well, it allows you to control essentially what happens to your estate when you pass away. If you don't have a will in place, what happens is you die intestate, and your estate will pass in accordance with the intestacy rules, which are set out in legislation. Quite often, if you die intestate, what will happen is your estate will end up passing to beneficiaries you don't really want to inherit. Also, it may mean that you will not make the best of the various different exemptions that are available to you. Also, having a will is great from a financial security perspective. It ensures that you provide for the people that you want to. So, if you've got young children, you may want to have that peace of mind when you pass away that those children are going to be looked after. Also, partners are not catered for in the intestacy rules. So if you die without a will and you have a partner, you may have been with them 30, 40 years, never married, they will not be provided for and they will not inherit from your estate. So it's really important to take advice and to think about putting a will in place if you want a partner to inherit from your estate. Also, nowadays we see lots of blended families. So perhaps two individuals that have got together and perhaps even later in life, maybe earlier in life, but they've got children from previous relationships, and they each want to provide for one another, but they also want to ensure that their respective children inherit their assets on their death, and we can advise on that. Another point, it reduces the likeliness of a dispute occurring if you make a will, because a will sets out what your wishes are. It's not being governed by legislation, so essentially somebody else. You have that control. So hopefully by making a will and setting out your wishes, maybe preparing a side letter explaining your wishes, if you've chosen perhaps not to include, all your children or whoever it might be, hopefully it would reduce the risk that a dispute may occur in the future. If you do have minor children, it's so important to appoint guardians, and this is done via your will. If you do not have guardians appointed, what would happen is your children would be placed with someone or some people by social services. And what might happen is they may get put with somebody or some people that you wouldn't necessarily want them to be put with. By putting it in your will, then you get that control as to where they live, as well as appointing guardians. You can also put further wishes and instructions either in the will itself or in a separate letter to give the guardians guidance as to what you may like to happen with regards to your children, whether that be in regard to education or it might be something to do with maintaining contact with the wider family. It's really flexible in that regard. It's also great, for providing, asset protection for future generations, as I've already mentioned, just making sure that you are passing your estate on to the people you want to, but also in a tax efficient way. With wills, we do recommend everybody does have one if you've got assets, but a will that you make now will probably unlikely be your forever will. Certainly if you're making it in your younger years or before you retire. We do always advise clients when they are making wills to make sure they review them every 3 to 5 years, just to make sure that they still meet their wishes, and if they do want to make any changes, of course, to get in contact. So just a little bit more on the pitfalls of not having a will. We often find with individuals that have passed away who don't have a will that the administration of the estate is much more costly and a lot more time consuming. I personally have dealt with estates over the years where they've died intestate and we've had to track down as many as 50 different beneficiaries, and that's just for one estate. And you can imagine the time that takes and the cost involved in doing that. So it's a lot more straightforward if you put pen to paper, so to speak, and just make a will. You've also potentially got somebody administering your estate who you wouldn't choose, perhaps you wouldn't trust them to do it. So because you've lost that opportunity to appoint an executor by not making a will. You've also got the situation where you potentially got unwanted beneficiaries, people you wouldn't want to inherit. Lots of people assume just because they're a married couple that everything will pass to surviving spouse if they pass away and they don't have a will, but that may not be the case depending on the value of the estate. So it is really important, to make sure you make the will so that the beneficiaries you want to inherit do inherit. because effectively, if not, you are losing control of that decision. And again, it's the potential loss of tax planning opportunities. So just going back to the intestacy rules, if you are a married couple and the value of your estate is such that not all of it passes to your surviving spouse under the intestacy rules, there could end up being a tax liability on first death, which could have been avoided if everything had passed to spouse. So there's lots of tax planning opportunities that could be lost. Now Nicole's going to talk about business assets within the wills.
Yeah, so as Kerry's just explained, obviously wills are particularly important for estate planning, inheritance tax planning, succession planning in general, but in particular in relation to business assets. Without a will, your business interests may pass in accordance with the rules of intestacy, which Kerry's just touched on, or may pass in accordance with the company articles. So a decision really needs to be made and quite early on in relation to a business as to what you would want to happen to your business interests in the event of your death. Do you want to leave your business interests to a spouse or civil partner or other family member, or do you want to keep those business interests within the business itself by leaving them to a business partner? It's a personal choice and there's no right or wrong, and it would vary depending on the type of business and the family structure. But it is important to ensure that you check any company articles and documents to make sure that actually whatever your wishes are can indeed be carried out. Some articles restrict who can receive interest in businesses, so it's important to check to make sure that whatever your wishes are can be done, and that the gift isn't restricted by the articles. Otherwise, that gift would end up ultimately failing. This is going to be something which is business specific. And as I said earlier, it's something which is going to depend on you and your personal circumstances. And there are ways in order to benefit a surviving spouse or other family member whilst also benefiting a business partner. And it might be a suggestion that you use a trust within your will to ensure that all bases are covered. Obviously, I'll come on to the inheritance tax side of things later on. But again, by using your wills, you will be able to have an opportunity to plan for inheritance tax as well. Kerry's just going to now talk about powers of attorney.
So lasting powers of attorney, what they do. So there's two different types of powers of attorney. There's one for property and financial affairs and one for health and welfare. And what lasting powers of attorney do is they essentially enable you to appoint someone or some people to make decisions for you in the event that you lose the capacity to be able to make those decisions yourself. The property and financial affairs power of attorney enables whoever you choose to make decisions about any property you own here in England. Also, any decisions concerning any financial assets you have. So the types of decisions may be in relation to pensions, bank accounts, shares, investments, life assurance. And in relation to the property, it might be renting it, selling it, maintaining it. The health and welfare power of attorney covers anything to do with your day-to-day life and well-being. So the types of decisions that your attorney or attorneys would be able to make include where you live, medical treatment, including life-sustaining treatment if you sign the appropriate box. What care you receive. It can be smaller things such as what you eat and drink, what you wear, what activities you do on a daily basis. So all of those decisions can be made for you if you're not able to. The good thing about powers of attorney is it enables you to choose who makes those decisions for you. In relation to the property and financial power of attorney, obviously they're going to be managing your money and your property. So you want to choose someone or some people that you trust to make those decisions for you. In relation to health and welfare, it will probably be choosing attorneys who know you quite well and know what decision you would have made in relation to your health and well-being had you have been able to make that decision yourself. The great thing about powers of attorney is that if something does happen and you do lose capacity, particularly if you lose it suddenly, it gives that sort of financial sort of stability for your loved ones or your business partners. They know that they will be able to step in and make decisions for you at that point when you're not able to make them yourself. You know, I always explain to clients, it is like having an insurance policy in place in case it's needed in the future. And if something does happen and you do lose capacity, the documents would be set up and registered and ready to be used immediately. So they're really flexible in that regard. If you don't have a lasting power of attorney and you were to lose capacity, what would happen is someone would, or some people would apply to the Court of Protection for something called a deputyship. Now, deputyships, generally speaking, take much longer to obtain than putting in place a lasting power of attorney. They're also a lot more costly, and there is a lot more paperwork involved with deputyship applications. In addition to that, they are highly regulated, mainly because the Court of Protection do not know that the person applying would have been the person they would have chosen as their attorney had they made the lasting power of attorney. So, for example, you have to file an annual report and you have to pay an annual supervision fee into the court. So they are a lot more highly regulated, but you don't have any of that with lasting powers of attorney, and that is why they are preferable, as well as you being able to choose who you want to appoint. And also you've got to factor in that, you know, at the point that someone's lost capacity, if they don't have a lasting power of attorney, you've got that time period between when they've lost capacity and the time when the deputyship is granted, where you're not able to do anything, which can put a huge amount of stress and pressure on families and you know, loved ones. We often get asked the question about, you know, what age should we make a lasting power of attorney? What age is too young? To be honest, the answer to that is it's never too young to make a lasting power of attorney. No one knows what the future holds. Lots of people associate losing capacity with dementia, but there are many other things that can cause loss of capacity, stroke being one, for example, where you could be fine one day and the next day you could have lost capacity. So the answer to that is it's best to put them in place as soon as possible so that they're there as that kind of insurance if something does happen in the future. With regards to businesses and lasting powers of attorney, so we get lots of clients that come in that have got businesses, and they often ask us, you know, what happens in the event they lose capacity with their business. Well, the answer is they could make a power of attorney to deal with that circumstance. So they could have one property and financial affairs lasting power of attorney to cover both personal and business assets. But quite often, it is much better for clients to have a separate one for businesses, for their business or businesses, and a separate one for their personal affairs. The reason being that quite often with businesses, the family who they may appoint for their personal assets are not directly involved in the business. They don't know how it's run and what goes on internally. So for them to step in and make decisions if they were to lose capacity would be actually quite difficult and quite stressful. Often people working within the business itself are much better placed to step in and make decisions if somebody loses capacity and they own a business. Whether a lasting power of attorney is definitely needed if you've got a business depends on the type of business that you run, whether it's sole trader, partnership, limited company. Certainly, if it is a company, we would always advise that the articles of association are looked at and reviewed before putting in place a lasting power of attorney, purely because they might already deal with what happens in the event of a director losing capacity. And our corporate and commercial team would be able to review those on behalf of any clients if they would like them to do so. And again, in relation to a partnership, there may well be a partnership agreement, which again may already deal with the incapacity of one of the partners. So again, we would advise that that's reviewed before deciding whether a business lasting power of attorney is needed or not. Nicole's now going to talk about business property relief.
So business property relief is an inheritance tax relief. As you might already be aware, in this country, you have what's called a nil rate band. That's an inheritance tax-free sum of £325,000, and that's the maximum amount you can leave at the time of your death without inheritance tax being due. This is reduced by any lifetime gifts that you make in the 7 years prior to your death. In addition, there is a residence nil rate band, but we're not going to touch on that today as it's not related to businesses and business property. But anything above the available nil rate bands is then subject to tax at 40%. And in some cases, that could lead to a rather large inheritance tax liability. There are some reliefs and exemptions out there, and Kerry's already touched on some of these in relation to spouse exemption and charity exemption. But in terms of reliefs, business property relief was originally introduced in order to reduce the need to break up businesses in the event of a death, where there's suddenly a large inheritance tax liability that needs to be paid. Business property relief applies at one of two rates, either at 50% or 100% of the value of the qualifying business assets, depending on the asset in question. In order to qualify for the relief, there are a couple of criteria that must be met. The first of which is that the business asset must have been owned by the deceased or the person making the gift for at least 2 years in order to qualify for the relief. When looking at the business itself, the business must be carried on for a gain and must not consist wholly or mainly of investments. So that is, it must not deal wholly or mainly with investing in securities, stocks and shares, dealing in land or buildings, or just making investments generally. Generally speaking, therefore, a trading company would normally qualify for business property relief, but an investment company would not. And in particular, a property which is dealing, or a company rather, which is dealing with property lettings or developing properties would not normally qualify for business property relief. As I mentioned a moment ago, there are two different types of business property relief. The first one applies to assets at a rate of 100%. And this applies if you have a business or an interest in a business which is carried on by you as a sole trader or partnership, or if you hold unquoted shares or unquoted securities, giving you at least 50% of the votes on decisions in relation to the company as a whole. The other level is business property relief at a rate of 50%. And this applies where you own at least 50% of the company shares in quoted companies. Obviously, this is quite unusual for an individual to hold at least 50% of quoted company shares. And the alternative is also if you own land, buildings or machinery, which is held by you personally, but used wholly or mainly for the purpose of a business, which is then carried out by a company that you have a controlling interest in, or a partnership. So if your business interest qualifies for 100% and you own property, land, buildings that's used by that business, it is likely that the value of the land, buildings and machinery would qualify for relief at 50%. Now, when looking at the business interest as a whole, we do need to consider the business in its entirety, especially if we're looking at the relief for 100%. And that's because HMRC will consider any surplus cash which is held within the business but not needed for the business itself. And if there is a large amount of surplus cash, then the cash itself would not qualify for business property relief at all, but the rest of the property interest may do so. Business property relief is therefore quite a helpful tool in relation to estate planning and succession planning. In relation to lifetime planning, generally speaking, when you make a lifetime gift, you must survive 7 years for the value of the gift to fall out of your estate for inheritance tax purposes, and you must not retain any benefit in that gift. However, if your business interest qualifies for business property relief and you are looking to make a gift of that interest, then if the interest qualifies for the relief, your estate may benefit even if you don't survive the full 7 years from the date of making the gift. The criteria, however, is that the recipient of the gift must still own the property at the time of your death or own some replacement property which qualifies for business property relief. And the property itself that they own or the replacement must qualify for the relief. If you decide to dispose of your interest in a business and reinvest those proceeds in a new business, then you will continue to receive business property relief on the newly held interest. So it's important that if you're looking, for example, to retire or to dispose of some or all of your interest in a business, to receive some advice as to how you could go about investing those proceeds in order to maximise the relief that might be available to you from an inheritance tax point of view. On death, again, business property relief applies, as we've mentioned already, and it will apply at the appropriate rate depending on your interest in the business itself. Consideration, therefore, needs to be given to who you want to benefit in your will, and is important, therefore, to ensure that you have a will in place. If you don't plan and have a will in place that benefits the people that you want to benefit, you may find that you lose out on business property relief. And what I mean by this is that if you leave your entire estate to a spouse or surviving civil partner, they would qualify for spouse exemption, and therefore there would be no tax to pay in relation to the assets passing to them. But if they are to receive all of the business property as well, then that business property relief would effectively be lost because it's not needed. However, if you're looking to benefit a combination of your spouse or civil partner and children or other family members, or indeed your business partners, then by leaving the business interests to someone other than your spouse, you would be able to maximise the reliefs that are available to you, especially if your spouse is not involved in the business or does not need to inherit those business assets. Another way of maximising the relief, but also retaining some control over your assets, either during your lifetime or on death, would be to consider using a trust. The benefit of a trust is that you decide at the time of making the trust or making your will who the trustees are to be. You decide who the beneficiaries are to be, and then you can leave a letter of wishes which is there to guide your trustees to set out the reasons why you've prepared your will in this way or why you've prepared the trust, and to give them some examples of how you want them to consider using those funds, and in particular which beneficiaries you would like them to consider benefiting and at what time. Although the letter of wishes is not legally binding, it does allow you to add some control to the ultimate benefit of those assets and the ultimate destination of those assets. Another advantage in relation to trusts is that if the assets qualify for business property relief when they go into the trust, and the trust continues to qualify for that relief, then there is no inheritance tax implications by making the transfer into the trust itself. And again, from an inheritance tax planning point of view, if your spouse has considerable wealth of their own and they don't need to have the business interests, then by paying the money into a trust, your trustees can assess the circumstances at the time of your death and decide whether your spouse needs to have any benefit from the business or whether other individuals should benefit instead. As we've already touched on, it is also very important to ensure that whenever making decisions about estate planning or updating your will, that you seek advice, not only about the potential tax reliefs that might be available, but also about what considerations need to be given to the company and the company documents, such as the articles. Obviously, at the moment, we can only advise you on the circumstances and the law that's in place for the time being, and with changes in government, business property relief may no longer apply. The advantage of leaving your estate to a trust is that your trustees can then consider what exemptions may apply at the time and make appointments out of the trust on that basis, taking into account all of the circumstances at the time of your death.
Thank you very much, everybody, for listening today. Has anybody got any questions at all?
Hello.
Hello.
Oh, hi, Kerry. It's Simon here.
Hello.
Hi, how are you doing?
Good.
Yes, thank you very much for the presentation. It's definitely very interesting. I was just wondering, we were talking a lot there about valuing assets in order to get an idea of what an estate might be worth. How do HMRC, so let's say you've got a business, I've got a business which is selling second-hand cars or something like that, and I run that with my brother. What experience have you got around how HMRC might want to value that business from an IHT perspective, and what process might they follow to get there? Is it literally adding up all of the assets and this is what the value is, or would it be more involved than that?
I mean, to some extent, it would depend on the type of business itself and the overall value of the business. If it's quite a small business, then they would certainly be looking at the assets within the business and any liabilities that the business has. They normally ask for the last 3 years set of accounts so they can see how the business has been doing. And we would normally recommend that they get a simple valuation from an accountant if it is just a small business. Otherwise, a more formal and specialist valuation would be needed to provide to HMRC. If it's quite clear cut that the majority of the business is going to qualify for business property relief and there's no sort of doubt about it, then the extent of the valuation I say isn't as important. Obviously, it's important, but it doesn't need to be quite as detailed. But if there is, for example, large amounts of surplus cash within the business itself, then it would be useful to have some sort of guidance from an accountant or valuer to try and support why that surplus cash is actually needed and why that should qualify for business property relief as well.
Okay, so still quite involved, but that would be the kind of thing that you would help.
Yeah, we can certainly help with that, and sort of where necessary, we would put a client in touch with an accountant if needed, if they didn't have their own accountant already, to assist with carrying out that valuation.
And then in relation to inheritance tax specifically, but in your conversations, does protection come into the conversation at all? So in terms of what's in the articles, so your key man sort of insurances, those sort of things, or do you not sort of go down that route?
We don't generally sort of cover the key man insurance and things like that, but we do always advise our clients to make sure that firstly they've spoken with someone who's got some experience in relation to the corporate side of things, who can advise them in relation to the articles and what's required by the articles. But also we always try and recommend that they get in touch with a financial advisor such as yourself to make sure that they've got the right covers in place, such as the life insurance, and whether there's any opportunity to take out life insurance to cover an inheritance tax liability that might arise later on.
Great. I have one last question, but not to sort of. It's actually in LPA, so the financial LPA. I'm just trying to clarify my understanding of when you can put that in place in order to support the donor, or sort of the actual the person that you're the attorney for. Can that be implemented before they lose capacity, so you're supporting them while you're working with them, or do you need to wait until there's a doctor's diagnosis of a loss of capacity?
No, you can do it also whilst they've got capacity, and I perhaps should have mentioned that. So with the property and financial power of attorney, you can tick a box to say that it can be used with your consent whilst you've got capacity as well as when you don't. So if you still have capacity and perhaps you're, I don't know, going abroad for a number of weeks or months, then you could authorise your attorneys, your business attorneys, if you have prepared a separate power of attorney document to make decisions whilst you're not there, whether that be, I don't know, running payroll, whatever it might be. And then when you return, you can take over making those decisions or doing those things again. Same if you were having medical treatment in hospital or something like that, then you can authorise your attorneys to make decisions, provided you tick that box. You can authorise them to sort of act for you whilst you're unable to do whatever it might be whilst you're in hospital. I hope that answers your question.
Yeah, just because I think that's a concern of my clients, is that they see, well, once I set up a power of attorney, who's going to make the decision about when I've lost capacity, and is somebody going to come in and take over? So obviously a lot of clients are worried about that, which is a fair concern, but they also understand that they need quite a lot of support in the interim. So like, doing online banking, just doing the simple day-to-day management of some of their finances, or joining me in meetings, they're quite happy for their attorney to do that. And so I'm trying to explain, well, look, you could do a power of attorney that allows for those things. And it's just teed up for the fact that if you ever did lose capacity, which is not guaranteed, that it would do a smooth handover to the next person. So it's just how I should explain that to clients, really.
I think it's emphasising to clients as well that the trust sort of point that I made, that it's important to pick attorneys that you trust. Because obviously if they've got capacity and they're asking them to make decisions, obviously they're going to have access to the document at that point. And it might be you're only asking them to do certain things at certain times, so it's trusting, they will only act obviously when you're asking them to do things if you've got capacity. That is really important, and then you're going to take back that control maybe at some point down the line. So that's something I certainly emphasize to my clients, is the importance of picking people you trust, because they are making really important decisions, if you lose capacity, and they're also obviously doing things to do with your money potentially when you do have capacity. You want to make sure they're acting in the right and the correct way.
Yeah, fantastic. Yeah, thank you. That answers my question. So I'm just thinking of ways that I encourage take away some of the worry about LPAs, because we find them absolutely vital in terms of what we do, and it's trying to explain, well, as soon as there's a loss of capacity, our hands are very tied, whereas we hold an awful lot of information about you and your finances and what you want to happen, and we talk about them every year. But as soon as, if you haven't got this document in place, as soon as capacity is lost, there's not an awful lot of help that we can be post that point. So why not just get this done, put it in a box, put it on the shelf, forget about it.
I always try and present it as a kind of insurance policy. I always think that kind of helps. You know, it's there as an insurance if something happens in terms of your capacity, or you need some help with something in the future. It's there and it's ready to go. That's the way I kind of explain it to clients, and then they think, oh, actually, no, would be good to have that and that peace of mind. And once they're set up and they're all done, there isn't anything further to do. You know, they're ready to be used as and when needed, if ever. But yeah, that's the way I would present it to them anyway.
Fantastic. That's great.
Thanks, Simon. Thank you for joining.
No worries. I hogged all the questions there for everybody.
Has anyone else got any questions? No.
Okay.
No. Well, thank you very much for joining us today.
Thank you very much. And
thank you.
If there are any questions afterwards, or if we can be of any further assistance, then obviously do get in touch.
Thank you.
Thank you very much, guys.
Thank you.
Thank you.
Bye.